Hi intellectuals, welcome to our channel. Company law has evolved since 4th century, gradually shaping corporate entities up to 2019. I have covered its evolution till 1956 in my earlier video. In this video, we will discuss from 1956. As any other legislation, various amendments were made to the Companies Act 1956 from 1960 to 1991. 1990 to 2000 is the era of liberalization, privatization, and globalization, which necessitated updating outdated companies' legislations. Companies Bill 1993 was initially formed but later withdrawn. Depository Act 1996 was introduced in India. A working group was formed to rewrite the Companies Act of 1956. Companies Bill 1997 was introduced in Rajya Sabha on August 14, 1997. President of India proclaimed the Companies Amendment Ordinance 1998 on October 31, 1998. The proclaimed Companies Amendment Ordinance 1998 was soon replaced by the Companies Amendment Act of 1999. The objective of Companies Amendment Act 1999 was to surge the capital market by boosting the national business houses, fostering the FITs and foreign direct investment in the country. The changes brought by the Companies Amendment Act 1999 are: a facility was introduced to allow the corporate sector to buy back companies' own shares. Provision relating to investment and loans were liberalized and rationalized. Requirement of prior approval of the central government on investment decisions was done away with, and companies are allowed to issue sweat equity in lieu of intellectual property. The compliance of Indian accounting standards was made mandatory, and the National Committee on Accounting Standards was also incorporated. The benefit of investors was looked into by setting up Investors Education and Provident Fund. Introduction of the nomination to shareholders, debenture holders, etc. was also introduced. Later, the Companies Amendment Act of 2000 was enacted, which was followed by the Companies Amendment Act of 2001, wherein the Section 77A was introduced in relation to the buybacks of shares, which allowed the board of directors to buy back the shares up to 10% of the paid up capital and free reserve, provided not more than one buyback of shares was made during the period of 365 days. Then, the Companies Amendment Act of 2002 was enacted, which was followed by the Companies Second Amendment Act of 2002. The first amendment introduced the setting up and regulation of cooperatives as a body corporate under the Companies Act of 1956 to be called as producer companies. The second amendment was to facilitate rehabilitation of the sick companies and protection of worker interests. The Companies Amendment Act of 2006 was brought into force on 1st November 2006, wherein it introduced the DIN number, which is Director Identification Number, and also introduced electronic filing of various returns and forms. The Companies Act 2013 replaced the Companies Act of 1956. The legislator introduced ideas of corporate social responsibility, class action suits, fixed term for independent directors. The provision of raising money from the public was made little stringent. Prohibition on insider trading by company directors and key managerial persons by declaring such activities as a criminal offense. It permits shareholder agreements providing for the rights of first offer and rights of first refusal, even in case of public companies. On May 2015, the Companies Amendment Act 2015 received the presidential assent and became operate on 29th May 2015. It is designated to address the issue of stakeholders such as chartered accountants and other professionals. Key amendments brought in the Companies Amendment Act of 2015 may be explained as follows. No minimum paid up share capital requirements will now apply for incorporating private as well as public companies in India. Relaxation have been given in relation to related party transactions which requires stakeholders' approval. This Amendment Act of 2015 has limited public access to such resolutions relating mainly to the strategic business matters. Such documents will no longer be available for the public to review or permitted to take copies of such documents. Under the Act of 2013, it was required to affix common seal on certain documents, but now After the Act of 2015, the use of common seal has been made optional, although the common seal is one of the integral characteristics of a company. The Companies Act of 2015 has introduced a proviso to set up the loss and depreciation carried over from past years against the profit of the company before declaring dividends to the financial year. The Companies Amendment Act 2017 brought significant changes aligned with SEBI and RBI rules, including omitting provisions redundant due to SEBI regulations. It introduced proportionate penalties, eased placement processes in private sectors, expanded the definition of private placements, and refined standards for independent directors. It also clarified pecuniary relationship exclusions. The Companies Act 2019 received the assent of President on 31st July 2019. The major reforms undertaken by the Ordinance of 2018 and 2019 includes the following: recategorization of offences which are in the category of compoundable offences to an in-house adjudication framework. However, no changes have been made for any of the non-compoundable offences. Delegation and declogging of NCLT by enlarging the jurisdiction of regional director by increasing the pecuniary limit up to which compounding the offences under section 441 of the Act can be taken place, vesting in the central government the powers to approve the alteration in the financial year of the company under section 2 subclass 41, vesting the central government the power to approve the conversion of public companies into private companies so as to reduce the burden on the government and developing the sector. Other reforms include reintroduction, declaration, commencement of business provisions, greater accountability with respect of filing documents related to creation, modification and satisfaction of charges, non-maintenance of registered office to trigger deregistration processes, and holding of directorship beyond permissible limits to trigger disqualification of such directors, etc. I hope you all learned about the evolution of company law and its reformation till date. I will come with another important topic in company law in my next video. Do follow the Courtroom Intellectuals for a further update. Thank you.